Well, we see people are joining as we speak, but we wanted to first welcome you. Our webinar this afternoon is Here We Go Again, Potential Employment Law Changes in the 2024 Legislative Session and What This Means for Employers. So last year in 2023, I had the pleasure of presenting along with my colleague here, Tom Hansen from our legislative group, to a client about some of the changes and explaining kind of what that means for employers. And we found that it went well. So we wanted to invite Tom back to talk to us so we could be proactive in thinking about what might happen this year. And also have my colleague, Amy Dayhoff from the Employment Department join us. So welcome. My name is Laura Pfeiffer. I coach our employment department. I've been at the firm for a very long time and work with employers on any number of employment law issues and navigating the changes that happened last year and that will be forthcoming. And Tom, I'll let you introduce yourself, and Amy too.
I'm Tom Hansen, and I lead our legislative practice here at Winthrop and Weinstein, and I came here from the Pawlenty administration about 14 years ago, where I was the management and budget commissioner.
Hello, everyone. I would say I see some friendly faces out there, but since I can't see you, but I'm assuming there are plenty of those out there. My name is Amy Dayhoff, and I am both in the business and employment litigation practice. I also do some litigation counseling, employment counseling, along with Laura. And so we are excited to, or not excited, depending on how you view it, talk to you about what's going to be happening this year. And it looks like we're going to have a lot of action again. So we do, before we forget and move on, wanted to let you know we're happy to try to answer any questions that you might have. So just reminder to use the Q&A function and not the chat function.
All right, so as a recap, I'm sure a lot of you know that a lot happened in 2023, and employers are still reeling from some of the changes and trying to adapt to them, and maybe are still getting in compliance on some of the issues. So just at a high level, non-compete agreements were invalidated as of July 1 of last year. Non-solicitations can remain. There's some changes that are being proposed that Tom will share with you, and we can talk about how to manage that. Cannabis, that was a big issue last year, and how employers needed to adapt to that and adjust possible drug testing or stop drug testing, and things to think about there. Earned sick and safe time, that became on the books as of January 1 of this year, right? So we are still working on a lot of handbooks for clients that maybe were slightly behind to make sure that they're in compliance. And there's some other changes that are being talked about there that we'll talk about. Pay history inquiry, paid family and medical leave. We'll spend some time talking about that. That's going to go into effect in 2026, but there's some things to plan for now. Pregnancy accommodations and parenting leave, nursing accommodations, and captive audience.
Whew. I'm tired, and now we're going to be even more tired. So 2024 is shaping up to be another really big year in the legislature for employers and employee-related issues. So what we tried to do, and Tom was instrumental in this, we're trying to flag things that are already are getting some action, of things that we think may see some action, and just wanted to put those on your radar so you guys could continue to monitor them after this webinar. So a few of those things are paid family and medical leave, and Laura mentioned some of this in her intro too. Earned sick and safe time, which continues to be and will be, I think, for the foreseeable future, a bit of a thorn in everyone's side as we're all trying to manage through this process that just went into effect in January and still getting guidance.
Proposed changes that we were both,
Totally
surprised about.
Very surprised. restrictive employment covenants and service contracts. This, I would say, was a bit of a surprise for me. I did not know that this was even being contemplated. So we'll talk about that. I know that in some industries, some of which our clients are in, this is going to be a really big deal. So wanted to flag that. Cannabis drug testing changes, again, it just went into effect this past year, already talking about some additional changes to it. The Personnel Records Act, wah seems boring, but there's some important information in that, and it's something that our employers deal with on a daily basis. So wanted to flag that. Salary changes, or ranges required in job postings. This is new, and there are a handful of other states that have already enacted this, of course, California being one of them, but all of the states' laws are looking a little different. So we'll talk through that. Proposed Equal Rights Amendment, which, as everybody knows, that's been talked about federally for a really long time. And there are certain states that have already enacted that, I believe 20 some, and Minnesota is now hoping to be the next. And then worker misclassification. So we've got a lot to try to get to for all of you. So I will stop there and we will get right into it.
So let's get started. First, the good news that none of the legislative changes we are talking about have become law yet. So the legislature just convened a week ago on February 12th, and they are going to be in session until on or before May 20th. The primary purpose of this year is to pass a supplemental budget and to pass a bonding bill. The legislature already has a 2-year budget in place, and they make modifications in this year. And I guess the good news is, if you don't want to see a lot of changes, is their committee deadlines and the whole process is geared to be fairly aggressive. So legislation is going to have to move quick. And if you listen to what the legislative leaders are saying, they're saying, and I'm going to use air quotes, no new major mandates, unquote. So they don't expound. Yeah, we're laughing. They don't expound on that. But I do want to also add, the reason we're seeing a lot of this is comes right out of the 2022 elections, in which the Minnesota voters elected a DFL House, Senate, Governor. And while we've had that before, it's really the first time that we've had a philosophical, fairly progressive control of the House and the Senate and the governor's office. So that has led the legislature to look and change the fundamental differences between employers and employees. We saw that last year, and then we see a lot of this going forward for this year. So the first thing that happened last year, I mean, the kind of the one that everybody seemed to pay attention to, is the Paid Family Medical Leave Act. And the Paid Family Medical Leave is a new program that, fortunately, not effective till January of 2026, but it provides paid leave when a serious health condition prevents an employee from working, an employee needs time to care for a family member or a new child, and an employee needs to tend to certain military-related events or personal safety issues. It was signed into law last May 25th, and then the law instituted a study, which came out on October 27th, and the Millman study, and that forecasts that the costs will be higher than predicted than when the funding was set in the last legislative session.
Significant amount, right?
Yes.
So,
Yes.
Oopsies.
Yeah, and I think Millman has already made some other recommendations of how to adjust some of the tax rates to account for this greater expense. And so, where those recommendations will land and what that ends up being for employers, it remains to be seen. But clearly it was far in excess of what had been predicted.
Yes. So wage submissions began in later 2024. November of 25, posting requirements began, and then contributions and benefits began on January 1st of 2026.
Let me ask you this, Tom. Any thoughts on, as you mentioned when you started this about the election that happened in 2022, trying to, pass all of this stuff. And given that this doesn't go into effect until 2026, thoughts on the odds of whether this will be repealed, it's before it even is put into action, depending on what would
Sure.
happen
Yeah,
in
I
the
mean, because
20.
it's a major campaign issue in 2024,
Yeah,
right?
we'll see.
Yeah, so-
Yeah.
We'll get to that. But this-
Sorry, I just-
Great question.
We're alert.
But just some details, it's being administered by DEED, the Department of Employment and Economic Development, and enforced by the Department of Labor and Industry. It does not include self-employed individuals, independent contractors, or seasonal employees, and it applies to all employers, and no matter how small. It's leave up to a total of 20 weeks. There was a lot of debate in the legislature, and it was as high as 28. And the business community got that down to 20. And actually, at one point, there was even 16 weeks, but they settled on 20. Premium rate is 0.7% of wages, shared 50% by employers and 50% by employees, but we'll have to stay tuned on that. As Laura said, the Millman study came back showing it's going to be a lot more expensive.
There
And
was
then,
a suggestion that to go up to 0.78 for the first 3 years.
yeah, which is a
So-
significant amount of money.
And then after that, was it 0.83?
Yeah,
Yeah.
after that, to try to even out, swings between different tax rates, so.
Yeah.
So then the small employers will be eligible for some grants, so be on the lookout for that. So as we said, and Amy was jumping ahead of this because she was so excited.
Hey, I'm sorry.
The legislative leaders do not expect, and so far there's no legislation making a major or even modifications to paid family and medical leave. And I think the reason is they don't want to get into the debate about how much it's going to cost. And as Amy said, there are 2 legislative sessions and an election before implementation, and this will be a major election issue for 24. As to the question of whether it will repealed, it's unlikely to be repealed by the time it goes into law because the Senate is not up until November 26th and the governors and DFL are. So I could see if the Republicans get control of the state house in this coming fall, and then in next year, some modifications to the program. Maybe they kick it out a year or 2 or something like that.
Okay.
So a couple questions that we got, we will be sending out the slides afterwards, so just for attendees to know that. And then independent contractors are excluded from paid family and medical leave. They are able to purchase coverage under the program. Seasonal employees are also not included. So those are 2 things. If there's an additional question after that, you can feel free to reach out to us afterwards. But a true independent contractor will not be included, but could opt in if they chose. So, all right. So moving to key takeaways for employers. I think a lot of our clients were still reeling from sick and safe time and trying to figure that out. And so really wanted to not be thinking about paid family medical leave because there was a little bit of breathing room with that, given that it's not to go into effect until 2026. However, I think there are some things to think about now and to just start being proactive about how to incorporate this into your business. So number 1, there is information from DEED where you can sign up. It will be in the slides that you'll get, but here is the DEED paid family leave page. And you can sign up for bulletins as they have more information. And I've signed up for that. I think there's been a couple that have come out so far, but I'd encourage people to do that. The next thing is to be thinking about what kind of coverage to obtain. So there are differences that could be considered between going private or using the state plan. And so first of all, as we understand it, we don't think anyone has been approved to do it private so far. There's going to be an application process. All of that is underway. There's a new, I think it's Greg Norfleet is the person who's administering it. He just came from Massachusetts that had a similar program in place. And so there's a lot that is being developed, but in starting to think about what type of coverage to obtain, going through the state, it's similar to unemployment. So the state will be, they apply, there's a benefit account, they'd apply for the leave, they get paid through the state would prove it or not. A potential pro with that is then you're not making the decision. So if the leave is denied, the employee can't blame you for interference with the claim. So depending on the employer, they may find it to be helpful or better for them to just use the state plan. However, depending on the size of the employer, and there doesn't appear to be a universal recommendation, such as like, okay, if you have this head count, that's when you should really think about private. I think that all of the particulars will need to be evaluated to see if that's something that you would think is advisable. But from some of the research we've done so far, having a private plan, depending on the population, it's possible you could get better pricing. You maybe have your claims processed faster, a better experience for your employees. I mean, a difference with unemployment is that employees are already gone. So here, like, there's going to be an employee that is currently working for you that needs to be out for a particular reason. And so normally they would be communicating just with you about how to do that and, you know, whether the leave was approved or not. And so to outsource that entirely is just going to feel different and just be something to consider, right? So, but all of these things I think are in the category of gathering information so that you can be better prepared for making a decision about whether to go with the state plan or the private plan as this further develops.
Yeah, absolutely. And Tom, have you had any communication with anybody about thoughts on any clients or people you're working with on where their heads are at right now on that?
I think a number of, larger clients that have more resources are going through these pros and cons on whether to do it private. But one of the considerations is, do you really want your employees to have to work with the state?
Right.
On benefit
Right.
Is that going to be something that makes it difficult to attract a worker to your company here in Minnesota versus somewhere else? So I think people are looking at and trying to determine whether that's the cost benefit that you have outlined.
Yeah, and I think a lot of the benefit providers, so like say you're a company that has short-term disability or long-term disability now, like it's a lot of those providers will likely offer these types of services. Perhaps that can be coordinated in a way that would be
Really efficient.
and helpful for your company. You're used to dealing with that, for example, like when the employee applies for short-term disability, the provider's making the decision, but you get information, that type of process you may already be familiar with. It may be, again, maybe cost savings with that. But again, a lot more to follow, but I do encourage people to start gathering information to think about that so that they're not making decisions too quickly or, without proper information once we get closer to 26.
Okay.
All right, so then just, and Tom had foreshadowed this, but there, for a 2024 to-do item, it's starting in mid-2024, and I think it's gonna be close to July, that most Minnesota employers will be required to submit a wage detail report, which will detail the quarterly wages and have the hours worked for each employee, their names, and among other things. So that is going to be submitted to Deed, and employers will get more information about that. But that's one item that's for sure for 2024. Again, in the proactive category, to start thinking about, once you decide how this is going to work, just like with Earn Sick and Save Time, you're going to need to make corresponding handbook revisions and thinking about and planning for that. And then starting in late 2025, employers are going to have to notify employees about the program. There will be a form that's prepared by the state that will be approved that could be used as part of that. And then ultimately, there'll need to be a notice at the time of hire, and then 30 days before premium collection begins, notice to employees about how that's going to work and an explanation of their rights. Again, all of that is going to be closer to when this actually starts, and then, you know, everything with premiums collected and all of that starts in January 2026.
And you'll notice a theme as we go throughout this presentation that there are a lot of new reporting requirements related to a lot of these laws, and handbook revisions, as well as notice requirements. So there's just a lot of stuff that you guys have to be mindful of and kind of have a checklist going forward, so none of these are missed.
Okay, earn sick and save time. Just by way of background, effective January 1st of 2024, an employee is eligible if they work at least 80 hours in a year in Minnesota, and 1 hour of earned sick and save time you earn for every 30 hours worked, with a maximum of 48 hours in a year, unless the employer agrees to hire. Earning starts immediately on being hired, and you're paid at the same hourly rate employees earn when working. So there are two bills that have been introduced. Neither of these have passed, that are proposing modifications. The first one is House File 3576. That hasn't been introduced in the Senate, and it removes an exemption. And it is right now, if you are employed by an air carrier as a flight deck or cabin crew member, you're exempt from the law. But now, if this passes, you would no longer be exempt.
And Tom, is there any rhyme or reason for this proposed change to that exemption? I mean, do you have any of the?
I think that the bill came together so fast last year that they probably erred on the side of granting some exceptions. And my guess is this isn't that big of a deal.
Okay.
Which is why they're doing it.
Yeah, to be fair, I don't think that this got a lot of airtime.
Yeah, no, I mean,
When I was reading
was surprised.
changes, I was like, okay, that's in the frequently asked questions right now, right?
Yeah.
But I
Yeah.
really had not had a lot of clients where this was an issue that required our attention, so.
No,
Not at all.
but we are thorough. So the next one, this one was introduced this week. Flip the slides. It's been introduced on the House and the Senate side by the authors of the bill from last year. And it's about a 10-15 page bill, and it looks like more of a cleanup type of bill. So the first thing, it makes employers liable to all employees who were not provided or not allowed to use earned sick and save time. So if you don't do it, it creates a remedy for your employees when it makes liquidated damages available.
Yeah, and on that, I read that a little further because I was wanting to know exactly what that
Yes.
meant, you know, and
I
so.
figured you would.
So if you deny an employee their earned sick and save time, that they can get the amount that they should have been provided, and then an additional amount, which so it's kind of double damages.
So it's
for
like
liquidated
a penalty,
damages.
right?
Right.
Yes.
Yeah. So and then if you don't keep proper records of what they should have been able to use, then it's 48 hours. So the total, you know, that would have been
Which is
for
substantial.
the year, and then liquidated on top of that. So trying to put some teeth into the process, it appears, for employers that are not moving forward with this.
Well, and what's interesting about that in all of our presentations and us attending various webinars ourselves, after this was announced last year, is, you know, it had been said, they're really just looking for, you know, they're really not gonna go after the employers, they're really just looking for good faith compliance.
At least right away.
Right away,
Yeah.
but now suddenly, I mean,
Well, at least
they're,
this is being proposed.
Yeah,
right? So
right.
we'll watch this, but you know,
Mhm.
obviously, we're already advising people to comply, right?
Of
You know,
course.
and to do it properly, but this was something that would obviously put some teeth into that, if there was someone that wasn't.
Mhm.
Yeah, and the bill also added or clarified that employee can use to earn sick and save time related to funeral services or a memorial or address matters related to death of a family member. And then this bill was introduced last Thursday in both bodies, and then on this Thursday, the 22nd, it already has a hearing in the House, so it is on a fast track.
Yeah, and just to follow up on the detail on the records requirements, so right now it says that it has to be on the earning statements. And so the change, or one of the proposed changes, is that it can be on the earning statements or an electronic system where employers can access the information, but you must provide the employee access to a company-owned computer during working hours that has the ability to print. So, one thing I'm thinking there is if people are already have taken steps to put things on the earning statements, it seems to me to be safer, because then you can
100%.
prove that it's there instead of maybe there's a snafu with the computer or the access to the computer or someone saying that it was there, but they really couldn't use it. And so, but I'm sure they were trying to make things somewhat simpler with that. So we'll see if that part of it passes as
And
well.
what I would say with regard to that too is exactly agree with you, Laura, because if you think about it, in some industries, what the businesses, some of our clients are in, their workforce doesn't all have access to a company computer with a printer. It's just not even
Right.
feasible.
Well,
So,
I've had plenty of arguments though, where somebody said that they couldn't see something, that was supposed to
Absolutely.
be on an intranet or otherwise.
Mhm.
And then we had to try to show that otherwise, right? And so
Right.
if it's on the earning statement and it's right there, and
Mhm.
it may be best to just keep it there. But more to follow on that as to whether that's an additional option for you in the event that you'd like to utilize that.
Absolutely. Okay.
All right, so key takeaways. Again, if you haven't done the work to comply with ESST now, please reach out to us so we can help. We won't embarrass anyone, but there's a very long list of handbooks we are still doing, even though we're close to March now, to help people get into compliance. So the best course of action is to just move forward now. We do think that the Department of Labor is looking for good faith compliance still. And so trying to take steps, being on this webinar, understanding what's going on, trying to get into compliance are all good things to be thinking about. Provide employees the leave, provide your policies accordingly. We'll have to adjust the earning statements. You'll have to adjust your handbook. And then watch for these legislative developments that we've mentioned or others to see if there's any additional adjustments that you'll need to make.
Yeah, and there are also one other thing to follow up with. There are a lot of FAQs on the Department of Labor and Industries website too, and that those FAQs continue to change because there are they're listening to the community and responding to where they're getting a lot of questions. So I did want to point that out too.
Yeah, and both with ESST and with paid family leave, there is an ability to submit a question.
Yes.
Right on the website. And so if there is a particular question you have, I'd encourage people to do that. Obviously, they're going to be the best authority on what the right answer is. But of course, we're always here to help you as well.
Absolutely. Okay, restrictive covenants.
We're now on to restrictive covenants, and this is last year, the legislature passed the non-compete agreements ban. This is now the next step in that process. And part of that movement I talked about a little bit at the beginning, where there's a fundamental change in the power between employers and employees. This, I think, certainly falls into that category. It's House File 3456, Senate File 3721. The House file was already heard and passed the House Labor and Industry Finance and Policy Committee this week. The House author is a South Minneapolis legislator, a DFLer by the name of Emma Greenman, who has been fairly aggressive on these type of issues. It basically prevents an entity that provides services to a customer from restricting the customer from directly or indirectly soliciting or hiring one of their employees. Also, a contract a service provider signs with a customer cannot restrict or prohibit the customer from hiring the employees. And then if an existing contract has a prohibited restriction, the service provider must remove the provision within 1 year of the passage of this bill. So it's important to note that this bill has not passed yet, still has to go through another committee in the House and a couple of committees in the Senate, and would either pass or not by May 20th. But I think represents a significant change in current law.
Yeah.
Yeah, and on this one, I do know that there is at least one of our clients that I think is on here right now, where this is a significant issue for them. And so, so a couple of things that you could be thinking about now. Number one, if you would like a copy of the legislation, we're happy to provide it. If you have trouble finding it, we can get that to you so you can see what the actual wording is. And then, you know, obviously monitor the legislation. We can assist with that. Other things that are possibilities is to talk to your legislators, leverage Chamber of Commerce groups that you may be a part of, and leverage other stakeholder groups. Maybe there's other trade associations that you're part of where like the collective efforts could allow for your voice to be heard in a different way. Or, you know, obviously you can talk to Tom too about other things that the firm could do to take action on this legislation. So, but in this one in particular, you know, in some ways people will think, well, this is just a follow through from some of the other non-compete legislation that passed last year. But I do know that for some clients that I work with, that the model that they have, that this would affect them significantly and that this would be an issue that would cause them concern.
Okay, now we're into cannabis drug testing. The legislature legalized recreational cannabis last year after years of debate. And of course, then that created a whole series of drug testing requirements, or what you can do and can't do if you're an employer. So last year, even with the 2023 changes, employers do not have to permit employee use, possession, or distribution of cannabis products at the workplace. Employers are allowed to discipline, and this is all current law now.
Yeah.
Employers are allowed to discipline employees for using or being impaired by cannabis at work if certain conditions are met. If an employer uses cannabis outside of work hours and off of the work premises, an employer may not lawfully discipline an employee for that behavior. Testing job applicants for cannabis use is not allowed unless such testing is required by state or federal law, or there is a statutory exception. And then finally, testing current employees for cannabis use is allowed under specified circumstances. So the legislature is now considering a bill 3516, and one of the problems that certain employers found was that delays in laboratory testing resulted in some employers, they'd have to administer the test, send it out to a lab, and by the time they got the test back, an employee might have taken another job. So they came up with this new oral fluid testing legislation. And it's,
So, you know, one thing I found very interesting about this, because I was like, okay, what does this mean?
Yeah.
You know, can employers handle this? Like, should they be doing this? And, but there's 39 other states that
They do,
already permit
okay.
that. And so I found that to be a bit encouraging, right?
well, and
So
they
that,
talked about this last year. I'm not sure why they
Yeah,
didn't.
that-
earlier.
Right.
That seems strange to me, given that there are so many other states that are already doing
Yeah,
this.
I
So it's
was-
not like it's this new.
Yeah, I wasn't sure
Scary.
exactly how many, you know, other
Mhm.
states were permitting that, right? You know, as a possibility. So,
Absolutely.
so I thought that that was important for people to know, because I was surprised by that myself.
Mhm.
Well, so the law, and I don't know if we need to go through all of this, but it gets into a very specifically defined what an oral fluid test is. You know, you can see it on the screen. You know, it has to be approved by the Commissioner of Labor and Industry, can detect certain drugs and alcohol, etc. Does not require the services of a testing lab. So there you don't run into that issue of
The
having
delay.
it go out and the delay.
Well, and possible additional, more cost with that,
Absolutely.
right? Like if you do it in-house, there's gonna be some cost, but it would likely be less expensive.
Yeah.
Um,
Well, it's akin to, I mean, not to digress here, but when the first COVID testing came out, right? And people were trying to decide if their employees were gonna go to certain
Yeah,
laboratories to go get tested versus then they started bringing in their own saliva tests and administering them at work. I mean, it's kind of akin to that. So,
Yeah,
and the
it
cost
definitely
savings
is.
was huge. And the turnaround time. Okay.
All right, so the one thing with this part though, just, and again, we don't have to read all of the slides, but like when I was looking at it, you know, one of the main advantages is that companies can do it themselves, right? You know,
Yes.
kind of just like you're just saying. But then if the test is inconclusive or invalid or positive, right, then the applicant has to go to a testing laboratory within 48 hours of the test to remain eligible for the job. So in some ways, like if there is uncertainty about it or a positive, then you go and get something more
Yeah.
Right.
definitive, right?
Yeah.
And so, so all of those things I think were interesting things to think about. And again, like if some employers did get used to administering some of these things themselves, or you know, you have somebody that could do it,
Already feel comfortable, yeah.
and depending on, you know, if you do have this issue that Tom's describing, where, you know, maybe you are losing workers because of that lag, something to seriously consider in a different way. All right, so our takeaways, and some of this is from before, right? So to change your policies to account for the 2023 law changes, stop pre-employment testing for cannabis unless the job safety sensitive or another exception applies. So if you haven't caught up on some of those changes, make sure that you are caught up on that and not doing that. All right, so some of our employers are not testing for cannabis at all right now, because
Right.
like even with any of the tests right now, there isn't a really clear test of present impairment. So something to just, if, you know, to back up altogether is like, maybe you don't need to test at all. If you are wanting to test, watch the developments on this oral fluid test and see if that's something that might work for you. You know, obviously, there are some pros to having a lab do everything, because then you're just taking yourself out of that equation and not having to administer any of it. If you maybe don't have some of these timing issues. But maybe, you know, considering the cost issues, it's something to think about regardless, especially if it's positive and they have to go to the lab anyway, right? So like since the vast majority, you know, for I'd say like a total population of drug tests are going to be negative. Maybe this is something that would really allow for additional information for employers about drug usage, and still maybe have some cost savings with them.
Yeah, absolutely. Well, and I also wonder, because there are 39 other states that have done this, whether it'll be easy and quicker for the state of Minnesota to find a provider that's, you know, they have to sign off on it, right? So it should be a quick finding those people that they have to agree to, right?
Yeah.
The approved providers.
Seems like there should be some ability to short circuit some of that, given that we are a little behind evidently on the use of oral fluid.
Exactly.
32 in other states.
Yeah.
Yeah, exactly.
The hearing, they made it sound like we were leading the nation.
Okay, now for Minnesota Personnel Records Act, the want I said earlier.
The want.
Yeah.
So the Minnesota Personal Records Act regulates employee personnel files maintained by employers. So as an employer, if an employee requests their record, the employer shall provide the employee with an opportunity to review the employee's personnel record. There is, I think, these are your next two.
Oh, no, that's me. So there, it appears when I saw this, saw what Tom had mentioned about this, I thought, why in the world are we even talking about the Minnesota Personnel Records Act? And so where I think the action is that there is, so just so you know, the Minnesota Personnel Records Act is Minnesota Statute 181.960 through 967. And there was a discrepancy as it's currently drafted. So in Minnesota Statute 181.960, and that lays out all of the definitions for the next, what comprises the MPRA. It defined an employer as a person who has 20 plus employees. But when you got to Minnesota statute 181.961, which is the review of personnel records by an employee, employer is defined as a person who has one or more employees. And so what they're trying to do in this legislation is to, so there's no longer discrepancy. What does employer mean? So basically, if you thought you had an out because you had to be, have 20 plus employees, they're changing that. And it's basically, if you have one or more employees, you have to comply with the MPRA. And I'll let you get into.
So the bill is introduced in the House and the Senate, and in about 20 minutes at 1 p.m., if you're finished with this and you want to watch the Labor and Industry Finance and Policy Committee in the Minnesota House, go to YouTube.
Exciting.
Type that in and you can watch the hearing. But it's going to be heard today and most likely pass.
So just a little primer for all of you, and maybe some of you on here maybe have not had to comply with it if you had less than 20 employees and you thought you were.
Yeah, I think most employers, like, it's somebody's
Yeah.
file, right? So I mean, we weren't
Exactly.
recommending that people deny
Absolutely.
an employee their file because of a 20 employee requirement, because it does look like, well, why are you doing that?
Exactly.
There must be something amiss with that, but in any event.
Yeah.
And usually somebody's mad about something if they're.
That's why
asking
they're
for their
requesting.
file.
Exactly. That's
The most common occurrence.
exactly. So just, a primer for all of you really quickly. A request always needs to be in writing. The employer has 7 working days to comply if the personnel record is located in Minnesota. 14 working days if the record's located out of the state. And just maybe some of you have forgotten this, there is no requirement in Minnesota to maintain certain types of records. Unlike in Wisconsin, the Wisconsin statute, for those of you who do business there, it's very specific about what needs to be maintained and provided. In Minnesota, it's not. Hopefully that doesn't change anytime soon. But what you do have to do is provide those access to those personnel records that are maintained. Personnel record is defined by the statute, and I just certain types that are not considered part of the personnel record are letters of reference, results of employer testing, medical records available from health service providers. And if you ever have any questions about that, we advise clients a lot on that. So, okay, so I've got all of this stuff and I have it kept in one folder. Do I have to give them all of this? And no, you don't generally is the answer, but it's important to consult with counsel on that, especially if you know that this is headed for potential dispute or litigation or some type of complaint being filed with whether it's a state entity or court of law.
Yeah, the safe thing is always to provide what personnel record is as it's defined, right? Because
Yeah,
then
absolutely.
it's just, you're only providing what you're required to provide.
Yeah.
And that's true even if you get a release, right? So short of litigation, even if the employee says, well, I'll release it and you give me all
Yes.
these other things, it doesn't matter, because unless there is a requirement under litigation or a subpoena, or then all they get is what is defined by personnel record
in
the
the statute.
statute.
That's
And
right.
So the safe things to do is to just follow that. And what an employer has as the file often bears some relation, but not totally overlapping with what, the statute requires.
That's exactly right.
I'm often pulling stuff out and saying, okay, like all of this comes out, it's not really on all fours with the statute.
Right.
And let's just follow that.
And as Laura said, it doesn't mean you ultimately wouldn't have to provide it if there is litigation or subpoena, but no sense in providing it right out of the gates. Also, you are only required to provide opportunity review every 6 months if it's a current employee, if a former employee once a year, for as long as an employer maintains the record. So that will depend on your employment retention policies. And then obviously, if you have any questions about that, and how long you need to maintain certain records under various statutes, that is important as well. And we're happy to help with that. Okay, salary ranges.
Okay, salary ranges. This is the bill that's been introduced in the House and the Senate, is similar to what's already in effect in California. And it requires an employer to disclose at each posting for each job opening the starting salary range, a general description of all of the benefits and other compensation to be offered to a higher job applicant. An employer that does not plan to offer a salary range for a position must list a fixed pay rate. A salary range may not be open-ended. So this is last year there was a bill that Minnesota enacted that prevented employers from asking an employee their
Right.
pay history. This is now the next step in that process to try
Transparency.
to create transparency for workers.
And when that happened last year with the job applicant, piece of legislation, was there discussion, Tom, was it a foregone conclusion that this was gonna be happening now, this legislative session, kind of this next step or
This
not?
really wasn't
Okay,
discussed, but there is this strain of thought that people who are at the lower end of the income scale are disadvantaged by their job history. And if they have to go in and say, I make this much, they're gonna not make as much going into the next job.
right,
And the whole idea is to lift them up.
yeah, okay. So key takeaways, I was looking into kind of what, what would be the genesis and what's the rationale for this? And, the main one, and everybody knows this, is the goal is to reduce pay inequities. And long-term, from an employer perspective, it may decrease, any types of claims, right? Wage discrimination claims based on gender, sexual orientation, all of those things, right? When you're forced to disclose this information. There are a lot of studies out, up to 73% of workers more likely to trust organizations that provide pay ranges. And as they've seen this allegedly in California, right? When this has been in effect there for a while. But they weren't losing out, right? Top talent, because talent was when you're looking at job postings and things like that. Well, if I can go to X and find out, but I can't from Y, why is company Y not being as transparent as company X? And it makes sense. And it's an impact on, but one of the things to think about and talk through with counsel, I think, is considering that impact on existing employees who started a lower wage. What is that going to do for internal morale, right? Something to just keep in mind. Again, this has not gone into effect yet, but it's something we're continuing to monitor. And then the other thing is just thinking about it, right? If you've never engaged in the process, think about researching and determining salary ranges now instead of waiting until this is enacted, right? It's kind of like the ESST, right? It's like you're digging out of a hole and this is something that is going to require some time. You're just not going to be able to.
Maybe like good information just for recruiting and,
100%.
retention and, in any event, right?
Right.
So,
So trying to spin this as a positive, this legislation, that maybe you'll get the wheels turning, and it may result in some fruitful information that you did not already know about your company.
So Equal Rights Amendment has been proposed, and in Minnesota, in order to get on the ballot, you have to pass the House and the Senate, but not get the governor to sign it into law. So the governor doesn't have a say in this. This is, as Amy said, it's been around since the early 70s. I won't read the language,
1972.
but then, 72. But the language, we could probably talk for an hour about it, but there are two specific, there's some specific language for your purposes as employers, and that is the phrases gender identity, gender expression, or sexual orientation would be added to the Constitution. And I guess I would leave it to you two to talk about what that potentially might mean, but that would be a new thing.
A new edition, yeah. And I would say, generally speaking, I don't think that this is cause for the sky is falling. We have a very robust Minnesota Human Rights Act that has also been in existence in the state of Minnesota for quite some time. I'm sure all of you are very familiar with this, fortunately or unfortunately. And those protections, sexual orientation and gender identity, are already protected. So from my perspective, Laura and I haven't had a chance to talk through this, but from my perspective, I'm not overly concerned that this is suddenly going to change the way companies do business and the protections that they're already providing.
yeah, I agree with that. I think that a lot of these things are already set forth in the Minnesota Human Rights Act.
Yeah.
So it's just making that corresponding change.
Yeah, exactly. And then and Tom could speak to this too, obviously, but it needs to be submitted as a proposed amendment for the 2024 general election, right?
Yeah.
That's what they're, and if it's
Absolutely.
ratified, would take effect about a year from now. And one of the other things I thought was interesting when I was looking into this, 23 states have already adopted state constitutional or constitutional amendments that prohibit the denial of the equal rights under their state law based on sex. So, we're kind of in the middle of the pack really with this. To be quite honest, so this isn't something, out of the ordinary. It's been happening around the country for a while.
So this next slide is really no surprise, given that we've spent 45 minutes talking about what happened last year and this year. The Attorney General has created a task force on worker misclassification. His purpose is to try to investigate the practice of illegally classifying workers as independent contractors instead of employees to avoid some of the financial and administrative burdens we've been talking about. There is in Minnesota law, a 9-part test to determine what is an independent contractor and what's an employee. And I just listed some of the major points on there. But if you flip to the next slide, the AG's task force came out with these recommendations about a couple weeks ago. And they're recommending to modify Minnesota's construction independent contractor statute to promote enforcement efficiency. They update Minnesota's construction misclassification law. They modify and strengthen penalties. And the next one, importantly, they provide a private right of action. And then they modify the contractor registration system. I have not seen a bill introduced yet. It's unclear whether that at this point it can get drafted in time and introduced, but we'll be on the lookout for that.
Yeah, and one of the things that the most interesting thing, for lack of a better term for me, was providing this private right of action by employees who are misclassified. I mean, that's a newfound thing.
Well, right, yeah, I mean, there's been a lot of activity in this space though, right? So, and some of our clients know this unfortunately through Department of Revenue audits.
Yes,
Or
yes.
I think that the main difference last year is that there were independent contractors that filed for unemployment.
Yes.
And then that's how there would be a field audit through unemployment to determine whether their workers were properly classified or not, because essentially the person was mad that they got severed as an independent contractor and then decided to see whether deed would determine that they were entitled to benefits because they should have been an employee, and that's how the conversation was getting started.
Yeah, and I would say
more and more activity on this.
100%. And, all of you that are monitoring just federally what's happening too, there is just a real focus on the misclassification of employees. It's a huge revenue source. And there's a real, federally looking at it in terms of, inhibiting people's rights to move around. And if you're putting the onus on that employee for tax-based purposes. And so I think that this is gonna, it will be interesting if it doesn't find its way into, there's not a proposed bill this year. I would be surprised if that doesn't happen here, assuming the stay status quo with the way the House and Senate are. So one of the things because, as Tom said, there hasn't been a bill introduced yet. Some of the things that you can do, because this will affect a lot of our clients tremendously, potentially, is sign up for updates. You should go to the AG's website. That's where that task force has been developed. You can provide public comment, monitor and attend task force meetings. They really are looking and encouraging community input on this task force. And, I would say, this is from the AG's office, but because as they view it, the misclassification is more widespread in the construction space and that industry, it's receiving more scrutiny. Something else to keep in mind is, if you're an employer, it's like, well, but this is just common industry practice. That's not an excuse or defense for a misclassification of an employee. And as I pointed out earlier too, a private right of action is being considered is likely going to result in a lot more claims and litigation. So,
well, I mean, if it's easier to do something.
100%.
Then more likely that the additional action.
Absolutely.
All right,
Okay.
this next slide are things that that probably don't affect you or people have talked about. I'm just, where the three of us are just flagging. So first, workers' compensation, despite the legislature passing a lot of employee-related legislation the last couple of years, labor and business are still working through the Workers' Comp Advisory Council to come to a mutual agreement on any workers' comp changes. I wouldn't expect, they've been negotiating through the council since last fall, and there aren't any major changes at this point on the horizon. As of February 20th at noon, anything we say legislatively is current up till the time we started this webinar. The other thing I wanted to point out, the Minnesota Consumer Data Privacy Act is being considered. The bill's been around for 3 or 4 years. Representative Elkins of Bloomington has been working on this. It's currently designed to protect consumer data and limit their and companies' ability to sell consumer data to advertisers. It's meant to regulate that relationship between companies and consumers. Does not at this point impact employer-employee relations.
And what I would say about that is yet. What we've seen in other states is it starts as a consumer data privacy act, and then it morphs into something much more. And actually, Laura and one of our colleagues, Lisa Ellingson, presented on this at the end of January regarding kind of privacy issues and what to be looking for. We'll be presenting again with the Horton Group in March. And so everybody should really be keeping this on their radar, because once it starts, then it tends to morph and it affects the employer-employee relationship.
And we all are being inundated with artificial intelligence, news articles, reports. The legislature is no difference. There have been various hearings, but no specific legislation designed to regulate it or the employer-employee relationship at this time. And then finally, I found this last thing interesting. Disability advocates, I've been a couple of news stories, some disability advocates want Minnesota to join other states in ending the sub-minimum wage for workers with disabilities, saying the practice is discriminatory and exploitative. And that's an interesting debate, because then if the wages go up, some other disability advocates have said, well, then maybe they won't get jobs, So I don't think this is happening this year. I haven't seen a bill, but it might be something somewhere down the road.
Has this had action before this
No.
session?
Not that
Okay.
I've seen.
Okay. Great.
So we did get one question on personnel records and whether it was you had to provide the actual file or was it view only? And so the statute is 181.961 if anyone wants to pull it up, but it says that you just need to make it available for review by the employee during the employer's normal hours of operation.
Right.
But I can tell you that when this comes after the person is gone, I don't like the employee coming back to the company. And so I will just have the employer prepare a letter that says, pursuant to MnStat 181.961, enclosed, please find a copy of your personnel record as defined by 181.960, I believe.
Yes.
And then attach that and redact social security numbers and other things, because I just don't want the person coming back in and being disruptive. But what's actually required is set forth in the statute, and it just makes it available.
Okay.
All right. Well, I don't, let's see, looks like we may, we got one question here. Does an addendum to an employment agreement invalidate a pre-existing non-compete clause? So that's a question that we just had at a luncheon that Amy and I went to. And there is some concern that by amending an existing non-compete agreement, that's an agreement anew in a way that would be a violation of the current statute.
Because it falls after July 1st.
Right.
Absolutely.
I don't know that that's entirely clear, but if there's an ability to do it a different way or document something in a different way, that would be advisable to avoid that argument.
100%. Perhaps even, we haven't encountered it yet. Well, at least I haven't. I don't think Laura has yet either. And whether or not there's particular language that you could use addressing that in some type of amendment. There's obviously been no action on it yet. We don't have any case law on it. So, but it is that's a great question, and we're watching.
Yeah, apparently
Monitoring
there's some law in California
Yes.
that suggests that, which the speaker that we were listening to was referring to as a cautionary tale as to why to try to be thoughtful about that. So, good question.
Okay.
All right, well, thank you very much, everyone, for joining us this afternoon. We hope that you learned something, and we will continue to follow these issues. If you have questions, feel free to reach out to us. And as these things develop, if it seems that things are further along or additional information should be shared, we'll consider a follow-up webinar. But otherwise, thank you.
Thank you.
Thank you.